All right, here we go. All right, guys, we're going to jump into, so just give you a little perspective of what we're going to talk about today. I'm going to briefly go through the changes again that I sent out a video regarding the changes in the buyer's agency agreement. And then going to go over, if we have time, there's actually a total of 5 documents I want to go through today, 3 of which are ones that have changed, and then 2 new documents that have been added to the forms. So that's what we're going to go through today, cover that. Obviously, if you have any questions, don't hesitate to raise your hand, just speak up, whatever that may be. But we're going to jump in and get started right here. And we'll go with the Google Chrome side of things. All right. So first thing we're going to do is we're going to jump into the buyer's agency agreement, which is Form 130, and specifically go through the change that was made, just again, and make sure if you have any questions about it. So really goes down to the compensation, which is in section 5. So the change that was made here is twofold. There used to be 2 choices here under brokerage fee. One was simply that you were getting paid out of the brokerage, whatever that is. There's no obligation of the buyer one way or the other. That was removed to just have the one option as a brokerage fee. So immediately what tends to happen at this point, everybody starts to freak out. Why do we change that? So here's the main reason that changed, just so you have some perspective, is there is a big issue right now, particularly as it relates to Article 16 of the Code of Ethics, of buyers not truly understanding how their agents are paid. And so what was happening is this brokerage, this document itself was being referenced quite a bit to say, well, it just, said here that they were paid out of the transaction. There was no responsibility for me as the buyer side, which even though they never really physically wrote you a check, they were paying for the property, and then the net for that property included your fee. So that was one of the reasons it was pulled out. And then the other one came out was to allow this opportunity for you to protect your value as the buyer's agent, right? So you can put in here whatever you want. So that's kind of the evolution or the rationale of why it was changed to this. So here's what it looks like, jumping back into it. What that basically means is, and give me a thumbs up, Maui, if you see if you're back to compensation of brokers paragraph that you see. Awesome. Okay, so basically what this means is, make sure I don't have anybody in the waiting room. Okay, so same thing applies. First part of this is exactly the same. The buyer shall pay a brokerage fee of blank dollars or blank percent. You want to fill both of these out, either one of these out. We're going to start with percentage. So what I'm going to put in here is I'm going to put in 3% as the example, so we can talk about what this looks like, and we can walk through any scenarios. So let's just say for this, we're going to put in 3% for the example. That means that the buyer shall be responsible for up to 3% of the purchase price for you to be paid as their buyer's agent. This would also include for sale by owner properties. Then it goes on, and this was continued before, and then from before, it says any fees paid for by the seller and or seller's agent to broker can be credited against the brokerage fee. So in this case, we have a brokerage fee written in of 3%. Let's say the listing was offering out 2.5%. That means that that's applied to the 3%. And as it's written, the extra 0.5% would be the responsibility of the buyer. So it then goes on to say, like it did before, broker shall use the best efforts to obtain payment of the brokerage fee out of the transaction. But buyer shall have the obligation to pay the broker the brokerage fee set forth in this contract if broker cannot obtain such fee in the transaction. Okay, so all that's pretty much exactly the same as it was before. With me so far? Get some nods. Perfect. So this is where it gets a little different. So this next part is what was added. It says, in the event that the compensation being offered to the brokers from the transaction is greater than the above dollar amounts or percentage amounts, including any bonuses, then the buyer agrees that the greater amount shall become the new amended brokerage fee to this agreement. So what this is saying, same example comes in. Let's say you have 3% written in here. You have a listing that's offering out 4%. You have new construction that's offering out 3% plus a $5,000 bonus, whatever those may be. If that's the case, that fee automatically goes to you. There's no change that's needed from this document. Okay, it all stays the same. Now, you will then say, unless, again, it says here, unless otherwise agreed upon in section 17, which is the stipulation section down here, which would say, hey, in the event I get paid more, this is up to you, whether or not how you run your business. You could put in there, hey, if I make more than 3%, then I'll credit that to you or whatever it may be. That's up to you as whether or not you want to do it. The only thing that's added to it is in the event that this new amended amount, or you are making more, that you are then required to disclose the change in the brokerage fee, including any and all bonuses to be paid to the buyer, or excuse me, paid to the broker. And you would put that notice in writing to the buyer. So again, go back to the same example. You've got 3% in here. Excuse me. You put in new construction at 3%, then you get 5,000. You simply at that point would then shoot an email. They'd actually see it in the contract, but you could also send an email to say, hey, Evan, just, to let you know, according to our buyer agency agreement, we had in there that I was going to be paid 3% as a minimum, where there is a bonus in here, so I will be receiving more. And then you just give them that information at that point. Sound good? Okay. So the big thing that comes from this is what happens if you have 3% in here, and then you go out and you sell a listing and the listing's offering 2.5%. Okay, so this is where it gets a little tricky, because as it's written at that point at closing, the buyer would be responsible for the additional 0.5%. Now, a lot of agents, and again, I'm not here to regulate one way or the other how you run your business, but a lot of agents in that situation would not hold the buyer responsible for the 0.5%. They would simply take the 2.5%. Okay. If that were the case, and you had 3% written in the document, you would have to go back and amend this document. So if Evan's working with me as the buyer, he put 3% in there, the seller's offering out 2.5%, then technically you would want to go in or need to go in and amend this document to go to 2.5%. So then therein lies the question of, okay, how do we prevent having to amend documents? And there's a couple of different ways to do it. Number one is put 2.5% in here, knowing that the majority of the listings that are offering less than 3% are offering at least 2.5%, so you'll be covered. There are some people who are putting 0 in this. I don't recommend it, because I do believe that you should protect your value. However, there are agents that run their business in a way that if they're going to negotiate a for sale by owner, and the sale by owner is only going to pay 1%, or we've got, or let's just say you've got a listing out there that's only offering 2%. Some agents are totally fine with that. They'll absolutely take it. So if you put 0 in there and you go sell a listing that's only offering 2%, you then would not have to amend this document. It automatically becomes what your pay is. Okay. Make sense? Questions?
I do have a question, Joseph.
Mm-hmm. Go for it.
If the buyer's agency says 3%, hold on. The buyer's agency says 3%, and we only take 2.5%. And it goes to your accounting, because this is your agreement, not ours, right? This is your agreement. You're the broker. You're the representative. Is the broker is going to come back and say, "Hey guys, you owe me half a point because I'm charging 3%."
Well, okay, to answer your question succinctly, no. It's a good question, though. I guess one could argue that if you filled out the agreement to be 3%, but then only took 2.5%, that's why we don't have a standard in what to put in here for a buyer's agency. So to answer your question succinctly, no. You turn it 3%, you only take 2.5%. That being said, that's why you would want to change this for twofold. One, most buyers are going to want it changed anyway. Right, because technically how it's written, you could, you take 2.5%, you don't say anything to the buyer, you go to closing, you hand this agreement to the attorney, he can put the 0.5% on the buyer's closing costs.
Correct.
Right. Yet if you decide not to do that, question is are we going to come back and say, well, Greg, you had 3% in here and you only took 2.5%. You're going to cough up the difference in the company dollar that you owe us in the 0.5% or whatever it may be. The answer is no.
Okay.
Yeah. Yep.
I appreciate that.
All right. What else?
Can you go back and explain that 0% that you mentioned, but they will automatically get 2%? Yeah, you lost me there.
Yeah, so basically, as it's written, is take all percentages, whatever the percentages are. As it's currently written, you're putting a fee in here that says you as the buyer are going to guarantee I get paid at least this amount. Okay, so whatever this amount is, let's say it's 2.5%. How this is written, if you go to a listing and they're offering out 3, great, you get 3, that's the new amended amount that you get, no changes are going to be made. But if you go out and you sell a property that's worth, that's listing only offering 2, as this is written, the buyer's then responsible for that different 0.5%. Okay, so let's say your policy for your business is you're not going to go and actually collect that 0.5% from the buyer. You're totally fine taking 2%. Okay, let's just say that's the case. If you had 2.5% written in there, you would have to go amend the document, because technically what it's saying is the buyer still owes you the difference. So the reason that people would put 0 in there is they're just saying, listen, I'm fine getting paid whatever I get paid from the transaction. Whether it's 0.5% or 10%, I don't care. So I'm gonna put a 0 in here. So if I get 1%, 2%, 3%, it doesn't matter to me. I don't have to change this document at all. This document just says I'm getting at least 0.
Okay, understood.
It's a way to fill this out if you're fine taking whatever, which a lot of agents are. That's fine, whatever. It's a way to fill this out to not have to go back and amend it at all. I don't think it's the best business practice, personally, as an agent, but from a brokerage standpoint, it's not. We do have to understand that if you're not going to negotiate with your buyer, there's not a whole lot that you're going to be able to do to go get more money from the listing agent. Right. So that answer your question?
Yes, thank you.
Okay. The documents able to be previewed yet? Yeah, the documents were released last week, so they're all in zip forms. They're all uploaded, ready to go. All right, so let's go to a couple changes and some new docs. The next one we're going to go to is Form 370. You may tell me what Form 370 is before I pull it up? We'll pop quiz for you. Anyone? All right, so the 370 is the form which is entitled, whoops, I went back too far. Buyer occupy prior to closing. 370, buyer agreement to occupy prior to closing. So a couple changes were made in this. Will say that I do agree completely with the state attorney on this, and that the number one way to combat any issues with this document is to not allow the buyer to occupy prior to closing. However, if you are in a situation where you absolutely have a buyer that's coming in on a Friday with a moving truck and they cannot find a place to stay or do anything, and the closing is on Monday, this is the form that you would use. So a couple of things that were added to this. The first thing was highlighted, basically put on here, is that the intention of this form is for an occupancy of 7 days or fewer. Okay, we want to put that on there because honestly, if you're doing something where they're renting prior to moving in, or it's going to be a lease, this is a different scenario. If it's going to be for a longer period of time, they get just a whole new, this is a temporary fix. The other thing that was put on here is that this is specifically understood that the premises, should the premises be destroyed by fire or other occurrences during the time that the buyer is in possession, the risk of loss of personal property or bodily injury, including death, shall be borne by the buyer. So what this is also saying, and just so we understand, is it's basically once the buyers come over the threshold, the buyer's taking responsibility for pretty much everything in the property. The seller has to maintain the property, yes. However, this is what tends to happen. That buyer moves in Friday afternoon and the AC goes out over the weekend. The buyer's taking possession of the property. That AC is now the buyer's responsibility. Okay, so we got to keep that in mind, which is something that a lot of people, myself included, weren't super clear on based on the last one, but this is specifically mapping out, hey, this is the seller's turning the property over to the buyer at this point. Okay. A couple additional things that were changed about it. Again, I'm not going to go through all of it. I want to go through the changes. First of all, specifically, they added a time frame. So they had the date, right? The date of occupancy by the buyer shall be this at what time. This came up because they had people showing up at midnight, showing up at all hours of the day. So this just helped clarify when they're going to move in, whatever it may look like. The other thing it talks about is that the buyer agrees to pay an occupancy fee. By the way, they changed occupancy fee. That's what they use if they took out rent. Any sort of any sort of mention of rent or anything they've got away from, because again, go back up to the top, this agreement is intended only to give the buyer the right of possession pending closing and is not intended to establish a landlord and a tenant relationship. So the occupancy fee must be paid in advance and paid to the date of closing. shall be made payable to whomever buyer will only receive keys and given permission to occupy the property after the occupancy fee has been paid. So just very important to understand that they cannot take possession of the property until the occupancy fee is paid directly to the seller, paid in advance. Whereas before it could have been collected later, which is part of the problem. The only other changes to the document come from, again, any reference towards rent has been changed to occupancy fee. So you'll see that kind of throughout the document change there. There's one last place, section 12. So again, going over the changes, not the document itself, those are the big things. Here's the thing to just keep in mind about this buyer occupying prior to closing. Avoid it at all costs. It really is in everyone's best interest if, from a liability standpoint, everything else is if the buyer can find some sort of temporary housing, an Airbnb, a hotel, whatever it may be, that is absolutely in the best interest of everyone involved. Because even though this says, because it said before, not landlord tenant, all these things, yada, 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 you can have the contract, you can have everything on your side. Let's be honest, once someone is in a property, if something goes wrong, it is going to be harder to get them out of the property. Yes, sir.
Old story, put it exactly what this was. People went into a unit. They gave us 60 days pre-occupancy. 45 days in, my folks had buyer remorse. They moved out, never paid a dime, and they used the unit for 45 days. And the guy, lost money.
Yeah. Yeah, it gives me heartburn when I see these. And we also know that sometimes there's just no, like, let's just say something happened right now. If you had a closing scheduled for today and that closing got pushed till Monday, there's not a chance a family of four is going to find a place to stay in Charleston, South Carolina this weekend. They're just not. So this may be the only option that you would have to draw on, right? So there will be times for it, but at the end of the day, let's try to avoid it. Okay.
I have a question.
Yeah.
Okay, so if this occupancy is part of the contract, is the lender gonna look for that on the closing statement?
So it wouldn't really pertain to this because it's the buyer occupying prior to closing. What it would pertain to is the seller occupying after closing, which we're about to jump into.
Okay.
Yeah, so great question. And it really, for this one, it doesn't matter because the lender's not going to care where the buyer lives until the closing. It's really after the closing where the lender cares. So let's jump into that. Great segue, Linda. I appreciate that. We didn't even plan that, y'all. Look at this. All right, so now we're going to go to our next favorite one, which is Form 375, which is basically the flip, which says the possession by seller after closing. So a couple things on this one, changes that were made. Again, this is intended to be something that is, this isn't you're purchasing this property and then a tenant staying in there, the seller's renting back from you for years. I mean, this is a temporary form where, something's happened, they're going to stay in, it's intended to be used for occupancy of 7 days or fewer. Again, it's not landlord or tenant relationship. And on this side, the seller is going to be responsible for whatever's going on in the property after they've stayed in the property after closing. Okay, so again, those are the similar changes. Additional changes, same thing. What time are they going to be out? Like they're going to be out on April 15th. What time? Is that noon? Is that 5 p.m.? Is it, let's get specific on here. All right, so this goes to your question, Lynn. Say that again.
Share the screen.
Oh yeah, probably share the screen. That would help a little bit. So section 2 is where what Linda brought up, which is the buyer agrees to inform their lender of this agreement and certifies that the term of this agreement will not interfere with any loan product buyers agreed to for the subject property. So again, you're looking at a situation where you're talking about a couple of days. This isn't going to be an issue. However, this is why this is important to use this on shorter terms, because if a buyer is purchasing a property and then the seller rents back for 30, 60 days, then that actually could be against what their loan conditions are, because now all of a sudden they're not occupying it within a certain period of time. So this is just a disclosure saying, hey, You're letting the seller stay into the property for a certain period of time, but it is up to you to let the lender know so they're not getting yourself in any hot water. And we've all told you to go let the lender know because we don't want to be held responsible for the lender getting upset that you purchased the property. Afterwards, again, other changes, we're doing the fee must be paid in advance. Possession will only be delivered upon this payment being received by the buyer before the closing. So obviously, the buyer has to have paid this. Sometimes that's going to be paid out of the closing. If the seller needs to extend their possession, will not need that will need to be agreed upon in a separate agreement. Occupancy fee shall be paid to blank at blank. So this is where you put that's in there. Everything else again changes the same. They're using occupancy versus rent, and those are the changes that were made in there. We don't see this one really that often, not nearly as much as before. Or excuse me, not as much as the one for the buyer occupying prior to closing. Questions? All right, we're flying through. So new one, got some new forms that have come out. These will be interested to see how these play out. This first one, I think it's very needed and is going to be taking some getting used to. This is Form 530. This is what is called the personal property addendum. So again, this is an addendum. This would be added to the agreement, contract to purchase or sale. So this is intended to alleviate the confusion and issues that everyone has as it relates to what conveys and what does not. So as you know, on let me download this one and bring it up. So as you know, in section 3 or in Form 310, the first section, excuse me, first page, down here on the bottom, it talks about property, and then parties agree that no personal property will transfer as part of the sale except below and blank and any attachments. So you could put any attachments here and then reference the form 530 at this point, or you would reference it later in the contract. Either one is fine. I would say do it in the personal property one. You can also put it in section 28 here. What this basically says is this is a list of what's agreed upon personal property that would be conveyed. So a couple of ways you want to approach it. We're going to look at it from a seller standpoint and a buyer standpoint. From a seller standpoint, it's probably a good idea as part of your listing consultation to go through this and say, hey, here is what possibly could be asked for based on this addendum. If there's anything in here that you don't want coming, we can do one of two, or going with the property, you can do one of two things. Number one, go ahead and get rid of it. If you love the custom-made window treatments that were made by Aunt Honey 20 years ago, and you don't want them coming, then go ahead and take them down, right? Or in this agreement, in section 2, you can list out what will not convey, and then you could have this as part of your documents in the listing on the MLS to say, hey, if you're submitting an offer and you're asking for personal property, we've already got this filled out for you. Okay, so if you want to go back up here, we're going to go through it. Number one, buyer and seller agree that the following items, if present on the property on the date of the offer, shall be included. Now, again, this is if they're present that day. We're not asking for new things. That being said, if you receive this as a listing agent, make sure your client's not agreeing to things that are not on the property. They shall be included in the sale and as part of the purchase price, free of any liens. We're going to come back to that, unless excluded in paragraph 2 below. Seller agrees to unpair any smart devices that convey prior to closing. Items of personal property other than those below may be sold separately in the bill of sale in Form 503. So if you do get into a more complicated, particularly as it relates to furnished properties, rental properties, short-term rental, those sorts of things, you will need to address that separately in a bill of sale. Seller agrees that the items below include smart and traditional versions of the product, any related or necessary accessories, dedicated equipment, remote, and similar items. This was designed to encompass anything. So let's just take, well, let's see. The obvious one would be alarms and security systems attached for security, fire, smoke, carbon monoxide, or other toxins. This includes, this is a big one, any and all equipment, sensors, cameras, video doorbells, mounts, and storage devices for the alarm security system. So if that is on the property, when this is submitted, and everybody agrees that's staying. That's the biggest one right now. Our security systems, especially now because they're all wireless and basically seller installed, are those to convey. If you use this form, they are, unless otherwise stated. Appliances, they did not go with the blanket term of appliances. We went in with, okay, here's what we're looking at: all stoves, ranges, ovens, built-in appliances, attached microwave oven, vent, and hood. This would not include a refrigerator or washer and dryer unless it is truly built in. And then everything else you can look in here. Permanently attached ground plate equipment. It lists through most of the things that are in here. Some things that are interesting, just to keep in mind: TV wall mounts and brackets, any mounted speakers or intercom systems. So if your client is intending on taking those, then you need to specify in here that they are taking them. And then again, any changes or anything that is not included, you would include down here in the bottom to exclude it. Not required to use this. It is just an optional addendum to have in there. Questions?
Not required.
Not required, no. It's used, it was basically given as an addendum to help clarify. I would say highly recommended from my standpoint. And I say that knowing that the first few times this is used, it's going to cause more confusion than actually is, because people are just going to sign this and not look on there and well, here's what's going to happen, Greg. Somebody's going to sign it and say, yeah, sure. And then the buyer's going to move into the house and say, well, where's my video doorbell? And the seller's going to be like, I never had a video doorbell. Well, in here it says a video doorbell is coming with a property, which is why they threw in the little top line here that says if present on the property in the date of the offer, which of course, as we all know, well, there was one there. I promise I saw one. So that's why it's important when you review these, if you get them, this is just like any other part of the contract. If you get it as a listing agent, go through and make sure that the seller is okay with all of it. It also does help clarify the negotiations of what is included and what's not. Questions? Man, we're going flying through these. All right, last one. Last one is a new one that has been coming up. This is going to be Form 535. And Form 535 is the Vacation Rental Act Existing Short-Term Rental Addendum. So this is a twofold document. Number one, it is a document that is going to be used to make sure that we are stating to a buyer of a property that may have it's designed for a property that currently has any short-term bookings within 90 days of the closing. Okay, so this is first and foremost what this is intended for. It's not necessarily intended for homes that are possibly going to be VRB or short-term rentals or anything like that. It's some that already have some in place. It does two things. Number one, it basically discloses the entire South Carolina Vacation Rental Act. So you basically have a page of this, which goes through all the definitions and just cites the license law the law of that. And then what it does is it goes on to say, the above mentioned property is currently or will within 90 days of closing, whichever is later, have a vacation rental, and therefore the parties agree to abide by the provisions of the Vacation Rental Act. So the Vacation Rental Act says that if you sell the property, any bookings that you have within the next 90 days are to be honored. Right. So this is the first thing saying, hey, you're buying my property. I've got 10 bookings in the next 90 days. You have to honor those. It then goes on to say, after disclosing all the laws here, and just like anything else, it's very wordy, yet pretty much explains what it is. And it says, per the requirements set forth in the Vacation Rental Act, the buyer and seller agree to the following. A, there is a vacation rental management company, who that is, and then they can say option one, The seller and the buyer has received the full list of current rental bookings. So when you go in to make sure that they're going to give you all the information that's in there, or the buyer has not received from the seller a full list of the current rental bookings, and they agree that the seller is to provide the buyer a breakdown in writing of current and future rental brokers within 2 calendar days of this contract effective date. So one of the things that we've seen quite a bit, I'll actually go back to sharing the screen. One of the things that we've seen quite a bit here is someone purchases a property, they go into the property and say, hey, I know that we have rentals coming up, I need the information on it. What this states is that the buyer has to have that information provided to them within 2 calendar days of this effective date. I think that's a very reasonable period of time, obviously, because the buyer has to start acting on it. Second part, buyer and seller initial this, the buyer intends or does not intend to retain a current vacation rental management company. So again, the buyer does have to honor the rental. They do not necessarily have to stay with the vacation rental management company if there was one involved. And if they choose not to use that one, then obviously the seller would have to have a conversation with their management company. Seller shall notify the vacation rental management company within 3 calendar days of the effective date that they have accepted a contract for sale and whether the buyer either intends to retain the services, the seller to provide proof to the buyer that notice has been sent to the vacation rental company. So again, how this works out, we come in, we're accepting the property, we're going under contract. We've got X number of rentals in the next 90 days. The seller is going to provide us the list of those rentals, and then the buyer is going to decide whether or not they're going to use the management company. Once they've given notice of that, then the seller has to put the management company on notice that they won't be using them, and then they have to provide that notice to the buyer. With me so far? Okay.
Is the notice
After that,
is the notice in itself proof, or do we have to have acknowledgement that it was received?
all you need right now is notice that it has been sent. So they can provide a copy of the email or the notice is all that you would need.
Okay.
All right, then after that, if they intend to retain the service of the vacation rental company, parties agree that the buyer shall contact the vacation rental company listed above to coordinate the paperwork. If they do not intend to retain the current rental management company, that the seller shall contact the management company and request that no additional bookings be accepted after that date. Buyer agrees to honor all existing reservations as required by the South Carolina Rental Act. And then lastly, the parties acknowledge that the seller shall be responsible for providing the buyer with all keys, codes, lot programming instruction, pool passes, amenity passes, etc., to the property or common areas, and be delivering these items to the seller's closing attorney no later than the date of closing. This shall include replacement of or replacement costs of such items the seller does not have them in their possession. So this is a little bit different than the contract. The contract says you'll provide them if you have them. This is saying if it's needed, especially for these vacation rentals, then they will include the replacement of them or replacement cost of the items if they do not have them in their possession. And the rest is the signatures of it. Questions? All right, so looking back
Good
through,
question.
sorry, I missed your question earlier, Kyle, and then Maui, I come to you. Yeah, so these went into effect last week, March 20th. Yep. Maui.
No, I was gonna say you missed a question in chat, which was Kyle's.
Oh, sorry. There we go. All right. So what else can I share with you that will help you be smarter amongst contracts?
So you said March 20th is when it went to in effect. So I didn't use this recently. Do I have to go back and have them?
No. So for like the buyer agency agreement?
Yeah.
No, you will just continue. You'll use the one that you had. You don't have to go back and change old ones. This one just replaces these moving forward. All right, anyone else? Greg, you're muted.
Have you heard any updates on the lawsuit about the listing agents paying the buyer's agents? Anything updated on that? As far as
I actually, no, I got an update email that I've just flagged to read. I got it either this morning or last night, but I think is an update on that. That'd actually be a good broker minute to send out. To answer your question succinctly right this second, I have one, I just haven't read it yet.
because I think that's the important part with this new buyer's agency is you're gonna have to tell people, this is what I'm worth, this is my value. And if it's gonna be 3%, because I have a feeling they're gonna take that away. They're gonna say, seller, you can no longer, include the fees for the buyer side. So if we get people ready for that now, we'll have less of an issue when transition does happen.
Yeah, I agree with you. I think this is just a closer step to buyer paid buyer agency, which again, it already is, right? It's just covered by the purchase price, right? Now moving forward, let's just say what Greg's saying, fast forward happens tomorrow. All of a sudden buyers are the ones responsible for pay. Well, then it would be part of their closing costs, which is already stated in the contract, right? The contract already stipulates that part of the buyer's closing costs can and will be their commissions that they're going to be paying. So again, the same thing would apply. You could still negotiate it all in. It's just being paid for there. So yeah, I think what I'm finding is a lot of people that are pushing back on this and I say this with love and respect, is when I talk to people and they're like, well, this is just too much. Like, I haven't had to explain this to buyers before. Now I'm really having to explain it. That's the problem, right? That's that reaction, unfortunately, and again, love and respect, if I'm talking to you, is the problem. Is buyers were not being properly informed as to what the buyer's agent was being paid, because we were actually going so far to the side we're saying we're working for free. You don't have to pay us, which a lot of people don't understand that was outlawed in the Code of Ethics years ago, like 2 or 3 years ago. You can't advertise your services as free unless you're truly not going to be taking any money from the transaction. And so what's happening is this is an attempt from the SCR standpoint to say, listen, let's not continue to condone the behavior of not having the discussion of what it's worth. And it's hysterical to me. I'm definitely on a soapbox. It's like teams would get vilified because teams are like charging a flat fee, or they're charging at least this. And it's like, well, that's honestly, it's the consumer knows it. The consumer's willing to pay it. They've sold the value to them. And there's very little, not few exceptions, there's very little confusion to the buyer of what that looks like.
Yeah. Good classes. Get them used to it.
Yeah. We need, yep. Kyle, you said buyer agency agreement, personal property, buyer prior to occupy, seller occupy after closing, and then the rental company one. So it's going to be forms 130 that we went over, 370, 375, 530, and 535. All right. Well, if there's no more questions, then you guys have an awesome Friday. I appreciate you being here. Questions will come up. Please don't ever hesitate to reach out and ask.
Thanks for good coming on.
Thanks, everyone. All right.
Good.
Take care.